Good evening. I, Dipanshu Agarwal, a student at National University of Juridical Sciences and a convener of the NUJS Society for Advancement of Criminal Justice, take the privilege of welcoming you all to the fifth digital lecture organized by the Society for Advancement of Criminal Justice. With us today, we have Mr. Maninder Singh, an eminent advocate practicing in the Supreme Court, Delhi High Court, and trial courts. Mr. Singh, practicing for the last 27 years, is an expert in litigation surrounding complex criminal matters. He has handled various cases under special acts like the Official Secrets Act, Prevention of Money Laundering Act, Explosive Substances Act, the UAPA, the Arms Act, etc. As an advocate, Mr. Singh has appeared in the cases such as 2G Spectrum case, Aircel Maxis case, the Reebok fraud case, Abhishek Verma prosecution case under the Official Secrets Act, case of CBI versus Veerbhadra Singh, the former Chief Minister of State of Himachal Pradesh, Ajay Makan forged letter case, JNU students case where students were charged in NDPS Act, and several other high-profile cases. Today, Sir will be speaking on a theme of the overreach in the Official Secrets Act 1923, defending rights of the accused. The Official Secrets Act has attracted quite an attention in recent times. The law applicable to the government servants and citizens provides a framework for dealing with offences of espionage, sedition, and other potential threats to the integrity of the nation. The law has often cited by the authorities for refusing to divulge information. Today, Sir will be talking about the law from his own perspective and will also be sharing what he thinks about the rights of the accused under the law. We are indeed honored to host you, sir. The moderator of today's session is Mr. Faisal Fasih, an assistant professor at NUJS and faculty in charge of Society for Advancement of Criminal Justice. Mr. Faisal sir is an expert in the subjects of Indian Penal Code, Indian Evidence Act, forensic science, consumer law, etc. Faisal sir is also known for delivering lectures to the various prison officials and is an important stakeholder in the academic circle of the criminal justice system. We are thankful to Sir for moderating the session. Now, I would like to request Faisal Sir to please take over and carry forward the session. Thank you so much.
Thank you, Dipanshu. I hope I'm audible. Thank you very much, Dipanshu. Right at the outset, on behalf of NUJS family, I extend a very warm and hearty welcome to Mr. Singh, and I also welcome all the participants who are present for the today's session. Well, Official Secrets Act, we are aware of that is anti-espionage law, which was originally drafted in 1889. We have the present, law that is amended version of 1929. And as Dipanshu has rightly pointed out, that there are a lot of controversies which have arisen in the present scenario. It seemed that suddenly something happens in the present, BJP-led NDA government, where a lot of people are charged under the Official Secrets Act since 2014. I'm just picking up this exact date. So the controversies which happened in Rafale, fighter jet deal and all, where I think the Attorney General, Mr. K.K. Venugopal, argued in the Supreme Court that this act can be applied against the Hindu newspaper for publishing certain documents. So they have one kind of setup where the bureaucrats and some of the attorneys and lawyers are arguing that this is a very important piece of law and it should be applied for the purpose of checking certain activities, especially for cases of spying and all. On the other hand, very interestingly, there's a contrary opinion from the scholars, from lawyers, activists, and especially journalists. They are saying that it is high time we must get away from this, British legacy, because especially after the present enactment of RTI Act and Whistleblower Protection Act and all that. So we would love to hear from you, Mr. Singh. At least we would love to hear on 4 or 5 issues on this particular aspect, and obviously you can go beyond that. So the first, we are interested to know about the constitutional validity of the act itself after the RTI Act and the Whistleblower Protection Act. That is one. Second, the argument of all the bureaucrats that if Official Secrets Act is repealed, as proposed by the Commission in 2006, and also the amendment has been proposed in 2017 by the committee which was appointed by the Ministry of Home Affairs. So the bureaucrats are arguing that it would become very difficult for the prosecution in cases of spying. So this is two. Second, third is since there's no clarity about the difference between secrets and official secrets. So what are the guidelines which the courts have framed for the purpose of demarcating secret with official secrets. So this basically the question is about the subject matter of this particular act. And finally, for me and for the student of criminal law, a very interesting point is about, since mens rea, that is the mental element, is not required for certain acts under the act. So don't you think that it is more about presuming the wrong or presuming the offense rather than approving the offense? So these are some of the areas, if you can explore and if you can help us, if in explaining to the students, and I would love to learn from you also. And so the system which will follow for interaction is there'll be a presentation for around 45 to 50 minutes. Then we'll open the floor for quick Q&A, that is question and answer. So I would request everyone not to type any question in the chat box during the time of the presentation, because that may be a distraction for the speaker. So once the presentation gets over, we'll give ample opportunity of time to everyone. So, you can type your question in the chat box, but please, in the beginning, don't interfere the speaker. So if you have any question for the purpose of remembrance, you can always write a note on that. So now I'll not waste further time, because, Mr. Singh will complain that I'm delivering lecture on Official Secrets Act. So I would request Mr. Singh to make the presentation of the Official Secrets Act. So it's all yours, Mr. Singh. And it's we are privileged and honored to have you here today, because you must be having a very, very busy schedule. So please go ahead, and thank you very much for taking time out today. Yeah.
Thank you, Mr. Faisal, for such lovely words. And I first of all thank Professor Faisal for for speaking on this wonderful subject. And I also thank the NUJS through the Vice Chancellor, Mr. Chakrabarti, for giving me an opportunity to address the students on this particular act, which is actually a very closed act. People have started understanding it now, because the number of cases has increased now. If I may say, I'll add to Professor Faisal what he just said. Since 2014, the latest RTI revealed, which is in the news, is that 50 cases have been registered, and 30 have been registered in 2016 itself, and 9 in 2015, and 11 in 2014. So it's a huge number of cases at this point. Yes, people who are affected the most are the journalists, because when you start reporting something which comes in your hand and it is a classified document, then Section 5 of the OS Act straight away gets attracted. So yes, it's a very interesting act to understand and to know. And I would first, Mr. Professor Faisal has given me a huge list of questions. I think that covers the entire universe right now, what is happening around this act around our country, in our country. So I will try to take it one by one. First, it's very important for us to understand the little nuances of this act. And I must tell you that I've worked in this line. I'm not an expert. I work in this line to do these matters, so I learn every day. And the other issue is we have to understand each case is dependent on its own facts. There is no formula for any case to understand a case, or to deal with a case as a defense counsel, or to represent your client. There is no straitjacket formula. You have to take the case as it comes. You have to understand what are the documents which you have been charged with, what kind of classification they have, where is this classification coming up. So we will deal with them in these 45, 50 minutes. But before I go into all that, I must tell you that this particular act, the Official Secret Act. Can I have the first slide, please, Sarthak? We must understand the introduction to this act, which is very important for everybody to understand. You see, this is basically known as a colonial legislation. It came into existence in 1843 when the British were ruling the country, and it overall it was the correspondence and the newspapers and the process revealed confidential information. Those officials, government officials, they were particularly charged into this. In 1889, this process culminated in the Indian Official Secret Act, 1889. Now, in 1911, when the new Official Secret Act was enacted in Britain, it was made applicable to India also. Now, this particular year is very important, because the World War had already started, was there, and this act became more relevant in that period, because lots and lots of spies were coming in, lots and lots of information was being shared here and there, and whatever the government was storing between them, it was shared on public domains, and everybody was privy to the classified documents. So this act came into existence at that time. So in 1921, if you see with the fourth line, there was a proposal to amend the law in India. It was initiated for the fourth time, and on 2nd April 1923, we have finalized, this act was finalized, and interestingly, this is in force since then. And there have been only two amendments which are known to us. That is one in 1951 and one in 1967. Now we will understand what was the scope of the amendments which happened at that particular time. If you see the scope of the amendments, the key scope was to widen the scope of 3 and 5. These are the main sections of this particular act. And it also burdened the prosecution to prove that accused, in fact, acted for a purpose prejudicial to the safety and interest of the state. When we read section 3, this particular line, please remember, I'll take you all to that the prosecution has to prove that the act of the accused was in pursuance to a purpose which is prejudicial to the safety and interest of the state. The offences under the act were made cognizable and non-bailable. Now, the 3 section, it's a punishment 3(1)(c) goes up to 14 years, and 3 for the other offences goes only till 3 years. Now, the last thing which was very important was in the old CRPC, section 337 was there. In this particular new CRPC, which came into existence in 1973, section 306, if you would read, is very important for all of us to understand. This is for the person who wants to turn approver. That is a person who says if there's an accomplice, he says I can become an approver. So a tender of pardon to accomplice was also incorporated. And this is actually now, if you see the new act, this is also mentioned in the new act. Also, there is a particular section where a tender of pardon to the accomplice under section 306 can be granted to a person who comes forward for this. So these were the key amendments which happened during all these times. So coming back to the nature of this act, we now have to understand what is the nature of this act. Now, this act, I must say, with the whatever we are going through, whatever we read, we prosecute, we defend, it is basically a draconian law. In the sense, there is everything starts with the day one. You are termed as a person who's an anti-national because you have been found with certain documents which are alleged to have been classified or for against the national security. You are a threat to the national security. Your purpose is prejudicial to the sovereignty and integrity of the country. So these are the things that this makes an act a very draconian law, because you have no defense at all. You can't say this was not recovered for me, or the contents please read at a stage, or you give me a benefit of bail at the initial stage. Nothing happens, because the only thing which comes in your favor is in trial. So that's why this act is called very draconian, very rigid, and the presumption of guilt is always against the accused persons from day one. And accused is bound to suffer the rigors of trial. Yes, we have seen many cases where people are picked up, people are detained, people are sent to custody. There is trial happening. There is the triggers of trial. There is no bail. And the trial goes on for long periods, and by the time the document is proved to be a classified document or the contents not harming the national security, at that particular moment there might be some change in the towards you. Otherwise, this act stands against you for everything, for bail, and you don't get bail so easily. So there is no straitjacket formula to ascertain the category of offense. If you see section 3. It tells you that, I will come to section 3 in a minute after this. It just tells you these are the things where your offense, if it covers under the defense forces such as Air Force, Army, or Navy, any document relating to that, it straight away goes to for 14 years. But for other matters, now we don't know what those other matters are, whether these matters are concerning to mining industry or the petroleum industry or the finance ministry. For other matters, they say it is 3 years. So there is no category of offenses defined in this particular act. The other important aspect which I found while trying cases in this is that the term spying an enemy, they have not been defined in the act. Only section 3 has one word in its definition when it begins, that penalties for spying. Rest, there is nothing defined. Who's a spy? Who's an enemy country? Who's an enemy state? There's a presumption for everything. There's a speculation for everything. So section 3 and 5 are so interrelated with each other that there is a very thin line which separates these two sections, which I'll try to discuss with you in the further slides. So I'll take you straight from here to section 3, which is an important section for this particular act. Can I have the section 3, please? Now, this is a particular section which says the heading is penalties for spying. Now, this particular word spying is not defined, as I just informed you all. It categorically says that anyone, please understand, if any person for any purpose prejudicial to the safety or interest of the state. Now, see, the first classification is approaches and or enters or passes over a prohibited place. This is a very big definition in this act. I will leave it like this. I will not go into details of prohibited place. Makes any sketch, plan, or model. C, which is very important for all the cases which we see happening around us, obtains, collects, records, or publishes, or communicates to any other person any secret official code or password. Please remember these two words. So, official code or password, or any sketch, plan, model, article, or note, or other document, or information which is calculated to be, or might be, or is intended to be. Now look, this is the scope of this act. Please read this line again, which is calculated to be. Now who's going to calculate it? Or might be, presumption, or is intended to be in future, directly or indirectly, useful to an enemy, or which relates to a matter, the disclosure of which is likely to affect the sovereignty and integrity of India, the security of the state, or friendly relations with foreign states, he shall be punishable under this act. Now, it doesn't stop here. It says all these things, now, if he does, and if it is related to the armed forces, it is for 14 years, you get punishment. If it is for any other purpose, it's for 3 years. That's the simplicity explanation of this. So if you read what we have mentioned on the slide, for a purpose prejudicial to the state, committed an act of spying, that is any act as detailed in 3.1 ABC, which I just give you a just now. Now, there is an important aspect here, which is section 3.2, where this act becomes extremely, extremely rigid and draconian. This is the rule of presumption which stands against you from day one. Now, this particular section gives the prosecution a handle to say that this man, there's a presumption against him that he has committed this act, and this particular section 3.1c is so rigid that you cannot get bail. And this particular section also raises presumption to such an extent that you have to be incarcerated unless and until there is a clear case, or you bring it on record that, look, this particular document is already in public domain. But my friends, this is also not the case in certain situations. This particular thing that it is in public domain, it also comes at a very later stage because you have to get it in evidence. So this is, I will read few lines for this particular section for you to understand that how dangerous this presumption is read against you. It says, on a prosecution for an offense punishable under this section, it shall not be necessary. Now see, the prosecution is very clear here. The act is very clear here, sorry. To show that the accused person was guilty of any particular act tending to show a purpose prejudicial to the safety or interest of the state, and notwithstanding that no such act is proved against him, he may be convicted. Now see, if from the circumstances of the case, now here you just have to, the circumstances of the case are enough for you to be convicted, or his conduct, or his known character as proved, it appears that his purpose was prejudicial to the safety interest of the state, and if any sketch, model, note, or any kind of document is recovered from you, or it is there with you, you are presumed to be guilty of commission of this offense. Now, this particular issue has come up in various cases. It has come up, people had a hue and cry on that it cannot be a presumption which is not rebuttable. So there are various courts which have given this judgment. One of them I've cited in this particular thing, Amin Chand and other versus state. This says, no, the prosecution has to prove its case on the way it has to prove other cases. You cannot read a presumption like this, that, all right, this is a permanent case. Now this man is presumed to be guilty and he will be convicted. The presumption is a rebuttable presumption. So this particular judgment which I have quoted, it's a very interesting judgment of Delhi High Court. This has to be read in this context, that the prosecution has to prove its case beyond reasonable doubt. Only then they'll be successful in getting the conviction for the accused they charge for Official Secret Act Section 3 and 5. Now, the particular section, I'll go to section 4 here. Sarthak, can I have section 4? Now, section 4, just hold section 5 here. Section 4 is basically an offense where common communication is done with foreign agents. Now, this particular section, section 4, is when you communicate with a foreign agent or a foreign person. So it is not necessary that you can be presumed to be in communication with a foreign agent if you have in the country or outside visited him, or if you have either you went to his address or there's any information connecting you to the foreign agent, so you shall be done. Your client can be completely charged with section 4 that you have met that man and we have recovered this thing from him or from you, and there's a allegation that he was a foreign agent or he was a person from an enemy state, or you have given him something which is classified. So you that is enough for this section to be invoked, and you can be prosecuted for this particular section. Now, so this, if you see, till now we have discussed that there is very little scope for the accused to come up in the incessant stage to say, all right, I have been falsely implicated, because everything would need a particular way of trial. There is no other way. You get your documents, nobody wants to see your documents. You get your defense, nobody wants to see your defense. It's only when the charge sheet comes, the charges are framed, and then only you start getting heard about your defense, when you start cross-examining. And otherwise, there is no way you can put your documents and say, oh, I go to High Court, and I say, High Court would also, in many cases, the Honorable High Court has said that go back to trial court, argue on charge, let's see what happens in charge, because nobody wants to understand, or nobody gives weightage to the documents you have or the clarity you have, or you say these are in public domain, because these sections are very strict and very, very rigid. There's no flexibility in that. The section 5, which Professor Faisal was referring to in one of his questions that he gave me about the people like a lot of journalists have done this and a lot of bureaucrats are talking about this. Now you see section 5 has a very smart difference between 3 and this particular section. It's a very smart line. Now one word which is mentioned here is not mentioned in section 3, and that word is possession. In section 3, you do not find possession. You do find obtaining and communicating. But in section 3, you don't find the word possession. In section 5, it becomes possession. So what is the intent of this section? This section says, if any person who is authorized to hold a particular document, a person who's authorized to have a document with him, and if he communicates that document to a person who's not authorized, this offense stands committed. Now, coming to the lot of journalists who, like even in the Rafale case, what Professor Faisal was saying, in the Rafale case, Hindu had published 3 documents, Note 10 and Note 18, along with one more document in its newspapers, which were picked up by the petitioners in the Rafale case, and they filed a review taking those documents in hand, and they say, all right, here is the case. So we need that court monitor committee be constituted. Court should monitor the entire case, and there is some corruption or or any kind of bungling in the Rafale deal. But the Honorable Supreme Court was very clear on that aspect, that they said no. The Attorney General, Mr. Venugopal, came over and he said, no, we are not going to deal with it. First, you came up with, first answer this, that why should they not be prosecuted for Official Secret Act? Because these are classified documents, and how do they have them in their possession? So there was a lot of debate on that, a lot of arguments happened, a lot of good law was laid down, and the Honorable Supreme Court finally came up with the view that Article 19, Subclause 2 of the Constitution of India cannot be snubbed like this. Freedom of speech is there. Source of documents, if they are good in public domain, does not matter. A very interesting line which came up, which I would like to quote here, which I found very interesting in that particular case, was public interest in disclosure outweighs the harm sought to be prosecuted. Please understand this. So they said the public interest in disclosure outweighs the harm sought to be protected. So they clearly said that, look, here, these documents, we will listen to the people, we will argue on the documents, but we are not dismissing this petition in limine at the first objection which was raised by the center. Now, OS Act was not allowed to be, and they did not apply that on the petitioners or on Hindu, because they said the documents were genuine, they have been obtained, that is not the issue. The question is, if they are in public domain, the OS Act becomes redundant. One another thing which came up in that was the RTI Act, which I'll take up a little later. Once let me deal with Section 5. Was RTI Act Section 22 also has it is completely contradictory to the sections of the OS Act and the provisions of the OS Act, which I'll just deal with. Let me finish quickly with the some important sections of this Act. So Section 5, as I just said, any person in authority. Now, suppose with that I mean as like we have a case. We were doing a matter which was an offshoot of the Navy War Room case. It was CBI versus Salam Singh Rathore. In that case, the prosecution case was that a DGM of the HAL, whom we represented, had communicated to a retired captain, Salam Singh Rathore, a certain set of documents which he should not have because they had come to him. Now, in that particular, those documents were initiated and from the originator in MOD, and they came to HAL Delhi, and from HAL Delhi, they were supposed to go to HAL Bangalore. Now, the case of the CBI was in Delhi. This particular accused, the commander working in HAL, whom we represented, had taken out the photocopies and had not sent the entire set to Bangalore. Now, when we defended him, we said, no, look, the documents there was a chain of custody which was broken, but Section 5 was charged on this particular gentleman. Section 3(1) was charged, Section 5 was charged, because the case of the CBI was that you were authorized to hold them, but you were not authorized to communicate it. So that was the case. So here this gentleman who Section 5 deals with such situations where the person authorized is having the documents and he communicates it and willfully communicates it to people who are not authorized. That's the crux of this particular section. And if you see in our slide, if you see the last line, voluntarily receive the secret document in direct contravention of this act. This is Section 5(2), and this is the crux which I just explained to you of Section 5. To attract the offense under Section 5(3). Now there are the 4 sections here: 5(2), 5(3), 5(4). Communicated directly or indirectly any document or information relating to munitions of war. If you read munitions of war, it is described in the definitions of the Act, which means all kind of like ships, tanks, all these arsenals which are used in war. They are called munitions of war. To any foreign power or in any manner prejudicial to the safety interest of the state. Section 5(4) is guilty of any of offences under 5(1), 2, 3, and that's a punishment which goes up to 3 years. So 3 and 5 have primarily small difference. 5 have people who are authorized to hold the documents and then they communicate it because there's no other way the documents can come out. 3 is a penalties for spying, a person who commits any act which is for the purpose prejudicial for the state. He can be any person, a person who's a foreign national, a person who is not a government servant, a person who obtains some document and is found to be giving it to an enemy state. Now, in one of our matters, it was also reported that one gentleman who was working in the army, he was posted in Delhi. He took out some documents on his pen drive, came out of the office. He went to Mahipalpur, handed over some documents to one gentleman. He was nabbed when he was giving those documents, and those documents were very sensitive. They were about the formations and locations of Kashmir and other valley border areas. And that gentleman who was caught with him was a Pakistani embassy officials. So because they have immunity granted here, because being the foreign attaches, he was deported back to Pakistan. And this particular person, Anil Kumar Dubey, was prosecuted and he was convicted also, and he was given 7 years for this. So he was in possession. He took that. So then Section 3 and Section 5. The difference is only this, which I have just explained it to you. Now, coming to the further 7, 8, 9, these are quickly, I will go through them. The 7th section is, if you see, it's for like interfering with officers of police or members of the armed forces. And here also the offense is about 3 years. And Section 8, imprisonment up to 3 years against any person accused under Section 3(9) of the Act for not giving requisite information on demand. If I am in possession of certain information and I don't give it to the CBI, I know my next door is doing something hanky-panky, or he's giving some information, or he's working in an armed forces office and he's getting information and delivering, and I do not give it to the cops, or I am privy to a certain information being in the office, so I shall be liable for this particular section. Section 9 is basically abetting of this offense, which means that I was continuously in aid, I was instigating it, I was in conspiracy, If you read section 107 of the IPC, we would understand what abetment is. Abetment is to aid someone, to instigate anyone, to be in party with anyone, to guard anyone, to conspire with anyone, or to intentionally be part of that conspiracy to commit that particular act. So then section 9, they have given separately that he will be prosecuted there. Now, section 10 is harboring. Harboring means if I harbor someone who is who's about to commit an offense or has committed an offense. Please understand. If somebody comes to my house and I know he's about to commit an offense or under this section, under this act, and I give him complete logistical support, or after he commits the offense, I send him out of this country, or I make him leave my house, or I give him some safe haven, so I shall be liable for section 10 being the harboring section. Now, there are two ways of search in this case, which the prosecution has empowered. Now, besides the CRPC, which has the provisions of search and seizure, this act particularly provides section 11 of the search warrants, how they shall be issued. Because the legislature, in its wisdom, thought that by the time you try to get the permission to search or the warrants, they can be delayed. So the search warrants are defined in section 11 very specifically and very clearly. Now, section 11 is defined in two parts. 11 subclause 1 is the power of the magistrate. Let's say the CBI or the special cell or a police wants to search some premises, and they have got the information. So, and they don't find it any urgency that the accused will run away, or it's a dwelling, or it's a factory, or it's a place where the classified documents or the material is lying. So they can go to the magistrate, ask for a warrant, and then they will come and raid that premises. So that's number one. Now, number two, which is very, very important, is 11.2, where the power is given to a senior officer, not below the rank of superintendent. In Delhi, it will be not below the rank of a DCP. Or in various states, the designation is different. A warrant is issued, and the police can straight away go and raid, citing that it is an emergency situation. We cannot leave it for even one day. So you need give us the warrants. We will go and raid, or this man will disappear, or the evidence is likely to be vanished, or there's a possibility of destruction of evidence. So this particular a warrant is given by the particular officer. So you don't need to go to the magistrate, that warrant is admissible in law. Interestingly, the one more aspect we must understand, section 11 of this act has to be read with section 100 of the CRPC when the raid is conducted. 100 CRPC it defines how a raid needs to be conducted with the search warrant, that you need to go there, you need to take the local police if it is interstate, or you need to have local witnesses of the society, and you need to make the inventory, complete list of documents which are recovered, and all accused need to sign that. So in many cases which we found, as with my experience in this kind of cases, I've seen that many a times the section 100 is violated. And it does become a question of law when you challenge this, or you ask the investigating officer in cross-examination or the other recovery witnesses that here you did not call anyone from the locality. You reached there at 6 a.m., but you did not call the RWA. You did not call the people living next door. So they have actually no answers to that. Very few cases where such compliances are done, and where the compliances are not done, I must tell you, the benefit always comes to the accused, because these kind of searches always are taken under suspicion. Now, coming to the trial of offences and section 13, I would request you all to please have a look at what is the classification of the documents. That slide, can I have it, Sarthak? Section 13, I'll come a little later. Can you come on the classification of documents? Now, what are the documents? We've been talking about all kinds of documents. The documents are recovered. So what are the documents which are required to be proved in this case to convict a person, or to have or charge a person for a particular offense? Now, the documents are top secret, secret, confidential, and restricted. Now, interestingly, which I just spoke about that, about the Act. In the Act, there is no such classification. We do not have the classification in the Act. It's absolutely, now from where do we get this classification? Let's say I'm arrested with a document which has a classification of top secret. Now, somebody has done that classification. So that classification is done by the directorate of that particular armed forces, be it Navy, be it Air Force, be it Army. So that particular person who's the originator of the document or the officer not below the rank of undersecretary can classify the documents. Now, how do we read all this? Now, I will explain to you what is a top secret document. There are very thin lines between them, and they are explained very beautifully in the manuals which are with each directorate. Now, what are these manuals? These manuals are given to directorates of Navy, Air Force, and Army to read before classifying a document so that there is no over-classification. That has to be checked. Now, what is a top secret document? I'll explain it to you. Top secret document whose unauthorized disclosure could be expected to cause exceptionally grave damage. Now, this word, please understand, exceptionally grave damage to the national security or nationalist trust. Now, with this category reserved for nation's closest secrets. Now, if with my little knowledge, I would tell you that I have come across some matters, some things where the top secret is mentioned, but it is not mentioned on something that I have to buy the radars or I have to buy missiles or I have to buy aircrafts. It comes only in the nuclear interests of a country or somewhere when the natural resources are involved to the top level, not on that is why it is called top secret, because it is over the ammunitions and of war or tanks or missiles or aircrafts or helicopters or the Navy ships and everything, because it is dealing with nuclear subjects. So it is a top secret. So this has to be taken into consideration. The second classification is secret. Now, the secret information is the one of whose disclosure may cause serious damage. Now, which damage am I talking about? To the national security or to the national interest, or serious embarrassment to the government. Now, see, if there's an order placed by the Air Force that we are looking for 16 helicopters for the Navy, or it is come from the Navy, this order that we need 16 helicopters, let's say our Sea King from UK or other Apache from US, or these helicopters with these kind of configurations, and those NSQRs, we call them national security requirements, are given. It comes to somebody's hand. Now, who will be interested in that? The vendors all over the world. They would know Indian Army or Indian Air Force or Indian Navy is looking to buy this. So this can be sent to our neighboring countries, which we call them enemy countries like Pakistan or China, because they would be interested to know what India is buying, what India is going to upgrade their. So this will be a secret document for sure. And if this document reaches somebody who is not authorized to have them, or somebody who is not an originator, or somebody who's not from the MOD, or somebody who's not in the procurement team of the armed forces, then this document, that man will be prosecuted for 3(1)(c), and the maximum punishment in that case is 14 years. So this would be a secret document in the views of in view of this act. So what is a confidential document? A confidential document is that information which might cause damage to national security, but it is prejudicial to the national interest, and it might embarrass the government. So these are very important lines, very important understanding of the words of the word classification. And the restricted on the fourth side is a document which is information. It means not meant only for official use, which is not to be published or communicated. Now, when some department writes the word restricted, so that means you're not supposed to publish it, you're not supposed to give it to anyone, you're not supposed to even discuss this with the press, it should not go in any books, and it will be a document termed as restricted. Now, documents which do not require security classification are absolutely unclassified. Those are the documents which can be discussed, they can be in public domain. So these documents which we've just discussed, the classification, this is absolutely to be with the people who are dealing with them, who are authorized to have them, and they are the documents which are in the top circle of the government, because they matter a lot for the sovereignty and integrity as well as the national security of the country. So now I hope the little bit of classification of documents which I could inform you guys is clear from this particular slide and my little explanation about each and every one. Now, as I said earlier, it is not mentioned anywhere. We have taken out these classification while cross-examining witnesses from these kind of directorates. They have come and given us the books from which they derive these kind of classifications. which are called INBR from the Navy, this thing, and also books of reference from Air Force and Army, where this classification is mentioned. And I must tell you, these documents itself, which are books of reference, are restricted documents. You do not find them in public domain. It's only when we also found them because we were allowed to inspect the files by the Supreme Court and by the order that, okay, you go and inspect the files. Then we came to know these are the documents that we have to, this is how the classification is done. Because the sole purpose of this particular act is to prove the document is secret. And what the defense has to prove, that the document is not secret. The document, even if it is secret, does not, there is no purpose which is prejudicial to the sovereignty integrity of the country if the document is admitted. Otherwise, I'll take up the issue of defense once I reach there. Can I have section 13, Sarthak? Now, section 13 is the section which has restriction on trial of offenses. Now I'm not really going to read the entire section. That is not relevant right now. What is relevant is that section 13 of the OS Act clearly defines that the court can only take cognizance of the offense under the Act if at all a complaint is filed by an authority of the appropriate government or some officer empowered by the appropriate government. Now, this is a very important description. The reason is, when you file a complaint, the magistrate can only take cognizance on the complaint. It cannot take cognizance on the charge sheet. It has to take cognizance on the complaint. Now, this when, and I have given a little bit of a description when I'll move further, that how the, in overreach, I have mentioned that how the prosecution is trying to circumvent this procedure, because the complaint case is different and a prosecution charge sheet case is different, which is called a police report case, and the other case is called a complaint case. Now, coming to why I say this, that the complaint is supposed to be filed, and and they are trying to circumvent the entire procedure. For that, you have to read these three sections, which are very important. 2D of the CRPC, which says complaint, and 2R defines police report. Now, I must tell you, complaint clearly defines that it is not a police report. What is a police report? Police report is a charge sheet, which the police investigates an offense and then files a charge sheet in the court. A complaint is when an officer empowered files a complaint along with his investigation and documents that here is a case, please issue summons to the accused, or if they are in custody, call them and start the trial. Summon them and start the trial. That's the difference in that. Now, what is happening here is, I would start here only because then I'll have to come back here. Section 201 of the CRPC provides a procedure where there is a complaint case and police investigation in respect of the same offense. Now, 210 says, if a complaint is filed and a police investigation is pending, the magistrate will stay the complaint and call for a report from the police officer and tag them together, and then the prosecution will begin. Now, why this section is used here by the prosecution? In various cases in Delhi. In 2006, the Navy War Room case happened. I'm lucky to be representing Abhishek Verma in that. In 2008, another cases happened. 2012, the cases happened on the OS Act. This has become a complete procedure adopted by the prosecution, CBI or the state. What they do is they file a complaint. The same day they move an application under 210. That's overreach. 210 of the CRPC. They ask for a stay on the complaint, and then they file a charge sheet on the same day. They get it clubbed. Now, what has happened in this process? The prosecution gets its way of getting the case tried as a police report case. Now, what is a police report case? When the prosecution first makes us argue on charge. Once the charges are framed, we will go under the prosecution evidence, then 313 CRPC statement of accused, then defense evidence, and then arguments on the final arguments. Now, when they have to come under the police report, the complaint case, what they have to do is, you will see chapter 19B, section 244, it starts. Then they have to first prove their case, then the charges would be framed. And in that proving, they will have to bring their witnesses. We will be cross-examining the witnesses. And if the matter needs to be charged, then the magistrate will charge, and then the further thing will happen. So this is to circumvent the entire procedure. The CBI or the other prosecution agencies, which we are seeing in Delhi, are adopting to this procedure. In a very important judgment of Anirudh Behel versus CBI, Delhi High Court has deprecated this particular procedure and has gone to say that OS Act is a special law and it will prevail over the general law. And you cannot circumvent the procedure, and 210 is not applicable to such facts and circumstances. And the prosecution against Anirudh Behel was quashed on this ground itself, that you have circumvented the entire procedure, which you could not have done. Now, then there are various matters which we are doing, which every other lawyers are doing, and they are all filed against the procedure adopted by them. And to inform you all, and they are still pending adjudication before the Honorable High Court, and there's a likelihood of them being heard in the near future. Now, this particular case of Anirudh Behel was not challenged by the CBI in the Supreme Court, so this has attained finality. So what I want to inform you people are that cognizance has to be on a complaint, which was the intention of the statute, but CBI overreaches it, it circumvents the entire procedure. CBI, whatever CBI means, is the prosecution agency. It can be state, it can be special cell, it can be the CBI. And finally, what happens is they circumvent and they start prosecuting you as a police report case, which is not permissible under the Act. Now, coming back to, can I have the next slide, please? Now, we've discussed about all this. There are two more sections before I go to the overreach. One section is section 14, which is exclusion of public from proceedings. That is, the camera trial can be asked by the prosecution by moving an application and saying that the camera trial be allowed. And what is the camera trial? The camera trial is that only the accused is present there, the prosecution is there, and the honorable judge is there. The evidence are recorded, and also the orders are also not made public. These days, the orders are on the internet, everywhere available. But once the camera trial is ordered, no public is allowed in the courtroom. There is no one who can get the orders except the parties concerned. So this is section 14. Now, section 15 is offense by companies. That is that the company is, or when the company is charged with the OS Act, the people who are in charge and responsible, like directors, managing directors, or the managers or others, are liable to be prosecuted for section 15, and as per section 15. So coming to the subject of this particular lecture, I hope I've been a little fast because of the time period given by my friend, that I have to complete that in 45 to 50 minutes. So coming back to the overreach, that what is, in our experience, the overreach, what we see is the false implication by any document picked up, even if that document is already in public domain. I've seen in several cases, the documents are there. There are several books where the requirements of the Indian Army, Navy, or any other country for that matter. Now we have in US, there is the Act, the Espionage Act. In UK, there is an Official Secret Act. And everywhere, there are books which are published to show that these are the requirements, that the Indian Army is going for that, or US Army is buying this. But when everything is public domain, still people are being charged with the false implication. That's one of the overreach of this Act. And the other point is that when you come to face charges, when you come and appear before the magistrate, the first stage is of 207 CRPC. That is, the prosecution is obliged to give you the entire set of documents, which they are not giving these days. They said, no, we are not going to, we seek privilege. Now, look at the section they seek privilege in. That is 173 subclause 5 and 6, which is a section they say, we will not give these statements or documents because they are secret documents, and an accused who has been charged with Official Secret Act cannot be given documents. Now, I must tell you, we have gone through a wonderful judgment of Calcutta High Court, which later on went to the Supreme Court. Superintendent of Legal Affairs, West Bengal versus Satyam Bhaumik, where the Honorable Supreme Court, in way back, now I must tell you the year, way back in 1981, had categorically stated that the documents which are part of the charge sheet have to be given to the accused persons. There is no way you can retain those documents. But then subsequently the law has grown. There have been conflicting judgments which have made this law a little little like in favor of the CBI, where they say accused should not be given. There is Vincentas case where there's one line which says the accused should not be given that document. And in lately, the cases we are doing of Official Secret Act, we have gone till Supreme Court. Finally, Supreme Court came to a rescue and said, all right, if you're not being given the documents by the CBI, it's okay, but you can go and inspect the documents. So I must tell you, practically what is happening is, we move an application for inspection. The CBI guy brings the entire set of documents. We inspect the documents. We make our notes, and then we cross-examine the witness. It is a little tedious, very tough, very difficult, but you have to do your job. One very important aspect here, which I must tell you, since you all are lawyers and you're going to be budding lawyers, or good lawyers in the coming future, you must understand one thing. When a lawyer is making a note of that particular document, you become responsible for the publication of that document. If those notes leave your office or leave you and reach in somebody's hand, mind you, you will not be out of Section 5, because Section 5 says you had the document and you publicize them. So this particular thing, you have to be very careful. When you are inspecting a document under the Official Secret Act, which is classified as secret, you shall not leave the notes in hands which are vulnerable, and it should not leave your office at all or your possession. So the next point is lengthy incarceration, denial of bail. The cases I mentioned is Jaspal Singh Gill and Vijender Rana versus CBI. These cases were Vijender Rana was given bail by the High Court, was again stayed by the Supreme Court. State versus Jaspal Singh Gill, bail granted by High Court, was denied by the Supreme Court. It was cancelled on the ground that this act is draconian. There are military maps found, military diaries found for him. So there is a presumption which runs against you much ahead of you. You can't catch that presumption, because the moment you try to rebut it, it goes away from you, and you have to only rebut it in the trial, not before trial. Now, this one important aspect which we feel is very important is overclassification of documents. Now, if a CBI or a government official or even an interstate department to department, any communication is done, everybody writes the word secret. Now that becomes secret. So in many cases, like Sama Abdullah's case, the Supreme Court came to the thing that you can't say secret and that becomes secret. Please see the contents. The word secret does not notify or classify a document as secret unless and until the contents are particularly secret and their disclosure is prejudicial to the sovereignty and integrity of the country. Just because the documents are secret, just because there's a classification mentioned there, that doesn't mean it becomes secret. And I must tell you, with my experience of cross-examining certain witnesses, they have come and told and given answers in the cross-examination like, oh, we have a procedure of classifying every document as secret. So this particular thing has to be taken into consideration. Why should somebody stay in jail for n number of years just to come out clean after several years that, oh, this document's classification was overclassified, and oh, it was in public domain, and it was already been printed and published. So this particular thing needs amendment in this act. And this is where the prosecution agencies take the benefit, because as on date, there is nothing on record to run contrary to the presumption. You are there as an accused, so you will be taken as an accused, because the moment somebody says, oh, he was found with documents where there is the procedure, the procurement was involved, or if you say the formations in Jammu and Kashmir, or formation in China, formation in the other border areas, those are secret documents. Something where you have AAP's annual acquisition plan of 2004 and 5, which is an obsolete plan, or which has been overrun by another plan in 2009 and 10, and that document is found from someone which is already in public domain and books are writing about it, but it has a secret classification, that cannot be secret. Somebody cannot be sent to jail for that, because the prosecution must be fair, must be there to safeguard the interests of the accused. Just because you have a case against me, that doesn't mean that you will throw me just for any document. And I'm saying these are classified, not classified, they're in public domain, nobody listens to you. Now, another thing is the books of reference, which are manuals, are reasonably classified. So we don't have access to them. So the normal person will never know why this document is classified. He can only rely on his information or Google's information. And mind you, the Google will not have the duplicate of the document which is recovered from you. It will have the excerpts from it, but it will never have the document. So you are still in a dilemma whether you are actually an accused or you were carrying something which was already in public domain. So these are a few examples of overreach. And can I have the next slide? Now, what is the defenses available. Let me discuss that, and I'll come to my friends, Mr. Faisal's question. Now, in our experience of what we found is these are not exhaustive. Just a minute. These are not exhaustive defenses. This is something which we see happening in courts, and as the defense lawyers, which you're going to be, you must understand what you have to deal with when you are dealing a case under the Official Secret Act. Now, we have to prove overclassification of the recovered documents. Secondly, you have to break the chain of custody of classified documents. You have to say, it never came to me, it was not recovered from me, or it is come to you, it was not sealed, or when it came to you, it was not having a proper, it was in several hands. I was not the exclusive owner of that document. So chain of custody of classified documents needs to be disputed by you. Third is documents already in public domain. You have to do a lot of research on that, because the witnesses, they come only once, and such matters, witnesses are not recalled as a matter of right. So whenever your witness comes, you must do extensive research that these documents are available in public domain. Also, you have to read the books which are printed for the procurements or for other installations or for other things, where you can interpret that these documents, look, this similar thing is being published again already, and it is already in public domain. So you have to do a lot of research on that. Now, comparison of recovered documents with original documents of defense. This is very important. What happens is, in a case of OS Act, there is obviously a recovery of documents from an accused. Once those documents come in, they are sent to DGMI. When I say DGMI, it becomes Director of Military Intelligence. Sorry. So military intelligence, it is sent to the military intelligence. Once it goes to the military intelligence, they compare that document with the original, what is with them, and then they give an opinion that yes, this document is our document, and it is actually a violation of OSA. Now here there are two views taken up. One, if they are only excerpts, so they will say if they are only excerpts, so the document is not there. So the onus comes on you. How are you having those excerpts with you? So you have to prove that, rebut that presumption. Secondly, if this is a similar document, so how the document has come to you? You have to destroy the chain, and you have to fight on this, that this document has been planted on me. It depends upon case to case, but it is very important that you must go through that report sent by the military intelligence, that it is a document with us, or the excerpts with us, or it is a photocopy of the document, or it is nothing but rubbish. Like I'll come to that case of Mr. Iftikhar Gilani. That is a very important case to understand in this particular act of OSA. Iftikhar Gilani was arrested in 2002 on the charges of having documents pertaining to military installations in Kashmir. He was in there in 9, so there were 9 months in jail. Now he was charged with serious offenses under the OS Act, and there were 2 prosecuting agencies, mind you. IB was doing its job, the Delhi police was doing its own job. IB said, here there is this military intelligence has said these documents are secret. When it came through the military Delhi police, they said these are only the excerpts, and this is already in public domain. It has got nothing to do with any violation of OSA. There was so much of chaos all over. The matter went to the highest authority of the country. When everybody started talking in press, the prosecution had to move an application finally to save its face, to say, we want to withdraw prosecution against this man, and he was released. Now, there's a difference here. When 321 application is moved, you are not charged, then you are discharged. If you are charged, if the charges stage has gone, you are acquitted. Now, this man for 9 years had been shouting, I did not do anything. There was a document already in public domain. Nobody would listen to him, because the issue was of being anti-national, issue was of national integrity, issue was of the country going through a lot of chaos at that time because of the various attacks happening in the country. So there were a lot of things which run parallel to you. And the prosecution agencies obviously take benefit of those, and they are already given, and the presumption there, that's why I say the presumption is against you. So after 9 or 10 months, this man came out of the jail, and he's written a lot of blogs. He's written his own story in jail. He's written himself that how he suffered the OS Act, which is a draconian law. And imagine, till today, we do not see any changes in this law, despite there being several cases of high-handedness where the people have been subjected to this particular act without any bail, and they have suffered trial and then finally getting acquitted. I've referred to certain cases. I'll come a little later. Now, the next issue is dispute possession of your recoveries. Now you have to, that's why I first said, when there is a raid in your premises or you are stopped, you must dispute by saying there were no public witnesses. You have to dispute the recovery, that the recovery was not from me. The police witnesses or the CBI witnesses have to be grilled properly. Your defense has to be very nicely knitted. You have to virtually go through each and every minute. All witnesses pertaining to recovery have to be crossed individually and on the same day, so that they don't become wiser. So you have to dispute possession of recoveries. Then you have search proceedings, which are interrelated. Those you have to dispute. Now, this is an important one, which I'm going to say right now, is non-sealing of exhibits at the spot. Sometimes the documents are not sealed and they're taken to the CBI office or to the prosecution done by special cell or by any other agency. So that particular aspect goes in the favor of the accused if you are able to prove that or dispute that the documents were not sealed at the spot. This is because then the chances of manipulation or the chances of mixing of documents cannot be ruled out. Now, the next is no independent witness, which I just said in the beginning, as per section 100, there must be independent witness. Supreme Court has gone to such an extent by saying that merely saying that few people came and gave their reasons of not joining the witness and left is not enough. You have to at least take their addresses, their names, their age. But mostly what I see in trials is prosecution coming up with this, that we tried to make witnesses, but everybody gave valid reasons and they left. So this also goes in favor of the accused if you are able to dispute that and if you are able to crash this from the case of the prosecution. Now, dispute the deposit of recoveries. Now, every recovered document is sealed and sent to the Malkhana. So so you have to also cross-examine or make your case good to this effect, that the Malkhana, there is a possibility that the documents were tempered or they were changed. So you have to work on that there was not clean deposit and it was with the investigating officer for a very long time, and the register sent to the court is manipulated. The non-compliance of procedure established in the CBI manual, if the case is prosecuted by CBI. Please read CBI manuals. Those are very important for every defense lawyer. CBI manual tells you the procedure, how the investigating officer has to conduct a search, has to take a personal search, has to arrest a person, has to register an RC, what precautions he has to follow, what safeguards there are. So you must read this manual before you start cross-examining CBI witnesses. Now, in case of armed officers, which I have written in the end, this is very important. In one of our cases, there was a person working in Navy. He was arrested for giving information to a Pakistani spy. He was arrested, picked up. But after 3 months, when his charge sheet was filed, the magistrate immediately took cognizance and sent and committed the case to the Sessions, because Sessions is the designated court. Now, here we have taken a point before the Honorable High Court that when a person is a servant in the service of the armed forces, the magistrate, before committal, he has to send a notice to the competent authority in the armed forces whether you would like to do court-martial and try your own process, or should we try in the civil court. This is very important. So the High Court has taken cognizance of this in our case, and the arguments are being done, and there is pending disposal. So there's a clear circular issued by the Government of India that if a serving armed officer is arrested, the first opportunity before committal of the case has to be given to the competent authority in the armed forces, whether for the purpose of court-martial or not. Next slide. So are we done? Okay, now these are some cases which I would like to discuss with you. In 2 or 3 minutes, I'll complete that. Now, what overreach was there in these matters? Now, Iftikhar Gilani, we just discussed between us. Now, K.C. Saini's case, in this case, a co-accused named someone that, he is the one who gave me these documents. And the document which I was with Mr. Saini was charged with were already in public domain. So the High Court came very heavily. It was after charge. The revision petition was filed, and that's why it's read as criminal revision petition. And High Court quashed the proceeding against him. And the next case, State versus Balram, which is very interesting for you all to understand. Now, this case is also the same co-accused with Mr. K.C. Saini. Now, his trial went on for 14 years. And he was acquitted by the Session Court. But all of them were acquitted, and they said prosecution failed to prove. Now, imagine, in 2003, Mr. Saini gets the relief. In 2013, Mr. Balram, after 14 years of trial, gets acquittal. Can somebody give his 14 years back? Come to the next case. That will open your eyes. CBI, Mr. K.K. Jadodia. 87, it was registered, 1987. He was acquitted after 31 years. by Ms. Kamini Law. He is a special judge in Delhi courts. Can you believe that 31 years this case lingered on, and this, because of the presumption against you, everything has to go through trial. There is no amendment at all till today in this act. The CBI versus Salam Sikh Rathore we discussed when we were talking in the beginning. In this also, the documents which were alleged to be communicated to Salam Sikh Rathore got convicted, Commander Kalra got acquitted, and 12 years of trial it took to get this case over. Who's going to, and this man, Commander Kalra, was in custody from 10th November 2006 to November 2009, 3 years. And later on, he gets acquitted. So there is no formula how to get presumption out of your you or out of your case against you, because you will only either be acquitted or convicted. Nothing is going to happen in between, and the incarceration is also phenomenal, and you have to suffer this trial because of the strict provisions, the draconian nature, and the rigid sections of this particular act. And coming to my friends' questions, Sarthak, is that all? Yeah, coming to my friends' questions about the constitutional validity and the other few issues taken by. Can you just remove this slide, Mr. Sarthak? Yeah, that's fine. You see, in view of the RTI Act, there is a complete confusion. I must say that, being a student of law and officer of the court, when I say confusion, what I mean by that? You see, RTI Act, thank you. In section 22, if you read the judgment of Rafale case, which I thought I'll have it handy to relate to that. Just a minute. In this case, all these three things have become very clear, what Mr. Faisal had asked me. And they have clearly gone to the extent of saying that they do touch each other, but then the overriding effect of RTI is coming from section 8 and section 8.1 and 8.2 of the RTI Act, which are the overriding effect. And they also say section 123 of the Evidence Act, we must also understand what is that before we come to any kind of conclusion. Now, we follow the judgments passed by the Honorable Supreme Court. We only read and see the sections. We can't interpret them in our own way. We can only follow them. Now, if you see section 8.1 of the RTI, it says, notwithstanding anything in the Act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interest of the state, relation with foreign state, or lead to incitement of an offense. 8.2 says, notwithstanding anything in the Official Secret Act, nor any of the exemption permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interests, which is what I read to you in the beginning. Let's read section 22 of the RTI Act, which is a clear departure from this, and it has a very specific kind of interpretation. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the OSA and any other law for the time being in force, or in any instrument having effect by virtue of any law other than this Act. So there is no bar. You can apply for documents and you can say that, okay, what is so official? Give us this. You can get it. But the 8.2 says something which is not in public interest, but then it should outweigh. I'll just read that again for you. So these two things are completely contradictory to each other, but then they were tested in the Rafale case, and the Honorable Supreme Court was of the view that besides 8.1 and 8.2, because they were asking for the application of the Official Secret Act on the Hindu newspaper, that they have committed this, how do they have these documents? The Supreme Court said Article 19 cannot be snubbed by any of these things. Freedom of press, freedom of speech is paramount, and that is why, keeping in view the RTI Act and keeping in view this particular condition, they said no OS Act, no Official Secret Act is attracted in this case. And coming to your next question of the bureaucrats, which I said, Mr. Fazal, the bureaucrats and the journalists, they are holders of certain files. Everybody is scared. Though people who give some documents under the RTI, or people who are in, or some movement is done in the files, the person who's authorized for the files, or journalists who have the documents in their possession, Section 5 will be squarely attractive. That goes on the public domain. So guidelines of classification, as you asked me, I just discussed about the guidelines of classification. They come out of the directorate. But to be very honest, the Act does not have any guidelines. Guidelines are solely dependent on the books of reference available with the concerned departments and nothing else. Coming to a very important aspect of mens rea, not required. You see, motive is in cases where there are no presumptions. Then mens rea come. You have to prove that I did not have any motive. There was no pecuniary advantage. I would not have gained anything. I would not have done anything. I cannot have the possession of this document. So I cannot have any mens rea. So that is a matter of trial. So motive in these kind of cases is important, but that comes in trial. Being presumption standing against you, you hardly get any chance, because you have to go through the rigors of trial to get yourself free from this case. Mr. Fazal.
Thank you very much. I hope I'm audible, because it was a wonderful presentation, I must say. Like, after a long time, I've heard this kind of presentation. So my understanding, like, I would like to explain this presentation in a way that I know lawyers' version of draconian law presented the most lucid of the language. So, the lawyer's version, I'm just pointing out, because, being a academician, we don't, we don't have that much of expertise and experience to, just break the law in that way. So three things have been pointed out, the lack of clarity, relaxation in the procedure, and, the unlimited presumption. So it boils down to just one thing. It's like a law can be applied by whim and fancy by the, agencies whenever they want. So even if a person is acquitted, like, the apt example of Iftikhar Jilani, that even if a person is acquitted and the prosecution help, that a person should be discharged, because all that was required, that document was in public domain. But still a person will go harassment for years. So that is the problem with the law. So now we'll open the floor. We'll take up questions. So question in the chat box, and maybe toward the end, I'll try to add something, or maybe just
we'll
take up question from participants. So please write your question in the chat box, and then we'll put the question. Yeah. So the floor is open for the question.
It's a little tough one to ask, actually.
Because it was such a good presentation, because nobody, yeah, because everything was clear, so nobody's having any question.
No, I mean, you see, I've been always scared of questions. Even in the court, I'm very scared of questions. So I like to disprove the case.
So okay, so finally, there's something from Samarth. That vagueness in the Act grant immense power to the prosecution and is prone to misuse. At the same time, the national security cannot be compromised. So this is actually a very good question. It's about balancing, because these days all of us are talking about the right of the accused vis-a-vis OSA. So Samarth has pointed out that can't we reach to some kind of consensus, or we reconcile the national security and the right of the accused? So please.
Yeah, Mr. Samarth, look, your question is in two forms. Number one, that the national security is important. I completely agree with you, Samarth. There is nothing more important than the national security. And as an Indian, I think we all are proud of, being patriotic Indians, and we should be very clear that the national security is paramount. But at the same time, if there are a lot of loose handles in the acts, such as even I must tell you, all specialized acts like the UAPA or the even POTA, when it was in existence, even TADA, even the PC Act, Prevention Corruption Act, or even this Act, OS Act, there is always something which stands against you as presumption, and then you have to suffer that, what I just informed to you. Now, when you say that in the second format, that the denied application of OS Act and kind of upheld the freedom of expression, so can we expect that future might witness a strict scrutiny? No, it's not that. You must read the judgment of the Supreme Court in the Rafale case. They did not say OS Act is not made out. They just said when the documents are already in public domain, they cannot be held to be a provision under the OS Act. And they were actually discussing about the RTIs in influence over the OS Act? Can you get documents under the RTI Act? That was the sole question there. So the Section 8(1) and Section 22 has to be read with Section 123 of the Evidence Act to get you this understanding, what you just asked. And in future, witness a strict scrutiny of the Act or even scrapping. You see, there have been a lot of commissions which have been put up. As we talk, in 2009, there was a commission. 2015, there was a commission. People are still writing things. What can be scrapped in this? What can be amended? You see, this is the only act till today in the independent India where amendments are minimalistic. There are very few amendments. Yeah.
Sir, there are a lot of questions. Yeah, earlier people have put up many questions. Can you please take them up?
But I can't see the question. Where
Sir, you can just close out. So there is an option of comments, private chat and comments. You click on comments, sir.
One second. I think. Oh, I'm so sorry. I'm new to this process. Okay. Wait.
Yes,
I'll take up.
Sir, can you please scroll?
Yeah. 1 second. I'm just going through it. Just yes, 1 second. Okay, so we'll start with in the order wise. There are actually quite a few questions. So, Mr. Singh, you should take water and deep breath, because there are a lot of questions actually. Because my mistake, the private chat was clicked, so I just missed all this point. Okay, I will start with the question of Priyans. Priyans has asked the question that to some extent. Mr. Singh, can you read all this question? I'm not sure. So we can start with Priyan's question.
Let me read what Mr. Agarwal has to say. He says, though to some extent secrecy is essential, what are your views on the contradiction between official secrecy and a citizen's right to information? Yeah, Mr. Priyansh, I explained it to you. Your right to information arises out of the RTI. There is no other right. They have been specifically provided to you after a huge revolution was started in India and RTI came into existence. Now, RTI is also having its own limitations. If you file something that I need information about the Official Secret Act, and if they come and tell you that, look, this particular information is in public interest, not given to you, this is the answer you will get. Because in public interest, they do not give you this information. They have to come in the category of public interest, then it outweighs the harm to the protected interest. So these interests are protected interests under the OS Act. They can only be given to you if the public interest overweighs the harm in the protected interest. Please understand this line. Go to Section 8, subclause 2 of the RTI. You will get your answer on that. But yes, I agree with you. There is a huge contradiction. Section 22 says that you can get documents. Section 8(2), which has been held up by the Honorable Supreme Court, also discussed in the judgment, stops. It has a very smart line that when the public interest in disclosure outweighs the harm of the protected interest, then only you will get it. So you are refused. Mostly when they don't want to give you any information, they will send you this particular answer. So Nitin,
thereafter we have Nitin question. So that's a new input. So he's trying to compare with UAPA, that how come UAPA can balance this related to the present.
Now let me tell you, UAPA is on a different flavor altogether. UAPA means it is unlawful activity, which is called, it is basically Prevention of Unlawful Activity Act. So it was initially not so draconian. It became very tough when it was amended after the UPA regime came to an end. So they started this particular amendment, and it is there since then. Now, in that particular act, there is a section 45 where the bail, 43, where the bail is difficult, not only difficult, it's impossible. Section 15 in UAPA defines terrorist act. It also not only includes the bombing or the death or the war against the country, like waging war against the country. It also has destruction of the economy of the country, which means if you are found with FIC fake Indian currency notes, you will be charged with Section 15 of the UAPA, and you do not get bail, because UAPA, the court has to come to a conclusion that you will be innocent after hearing the prosecution. So that 43 section is a very draconian section in UAPA. And your question is that what are your views related to UAPA Act? You have been involved. Yeah. So in this particular case, UAPA is for the terrorism and for the people who are waging war against the country, or who are involved in activities which are damaging the economic security of the country. But this particular act of the OSA has a different flavor. it goes with the documents in possession or for the purpose prejudicial for the sovereignty and integrity of the country, where you are sharing. There's a word called spying, where you are sharing important information like formation of troops. Let's say there are 10 regiments in JNK, and those locations are given. The location of the radars are given. The location of your ships are given. The location of your airports are given. Or Air Force makes or Sukhois, or where they are installed, how many. So these are very important installations. They will only come in the OSA. The UAPA will be related to the Terrorist Act.
Next, we can club the question of Astha with Aditi, because both of them, they are talking about burden of proof. So it's more about, the discussion on burden of proof and onus probandi. So we can club Astha and Aditi question both together. So basically, their question is about the scope of benefit of doubt when it comes to burden of proof. So we can club this together.
Yes, Aditi, I would tell you that benefit of doubt is the first cornerstone of our criminal jurisprudence, which always comes to the accused. It doesn't end. You don't get benefit of doubt only in the end. You also get benefit of doubt at the stage of charge. That if the prosecution brings a case and the court is of the view that it is not grave suspicion and it is only some suspicion, the benefit of the doubt goes to the accused. After trial, there are two situations. The court is stuck with two views. Should I convict the accused? I'm confused. Now with the evidence, should I convict the accused? Should I acquit the accused? At that stage, there are judgments to the effect. When there are two views possible, the benefit of the doubt has to go to the accused. So there have been many cases where the courts have given such judgments where they say the prosecution has failed to prove its case beyond reasonable doubt. When you use this word, beyond reasonable doubt, that means the case has not been completely proved and there are two views. The moment there are two views, the benefit goes to the accused.
Yeah. Next, we take up Mrunal question. So this time, there's a requirement of expert opinion from your end that how to resolve this, breaches, because which is a matter of routine under Section 5. So we all know. So if you have any practical answer to this, because
let me tell you, I am a person who has to appear in courts every day, and I suffer CBI and special cells and everybody every day. Though they are very, very, very. Let me tell you, they are high quality intelligence agencies. Their investigation is really good. You have to be very, very hardworking. You have to do your work very nicely to actually cross-examine the witness they bring and the evidence. If you have to break their evidence, you have to be very thorough with your subject. But you see, the national security, I understand your potential breach on the national security is often misinterpreted. That's very good. That's a good understanding. But please understand, this can be only resolved if the investigation is done properly in a manner that the investigating officer has to be unbiased, fair, and neutral. Many a times, they are always considering whatever has started, I must end it by a person's incarceration and send him to jail, whatever happens. So when let's say there is a question like there is something which is recovered from me and it is already in public domain, as I said earlier, and I am picked up and they say, there is a map of JNK which has been recovered from Mr. Maninder Singh. So without going into the investigation, so the investigating officer can clearly say, this is just a map. It is available everywhere. So it's all right. And he can close the case. He can file a closure. Yes, this particular aspect is only with I have seen very few cases where the cases are closed or where the closures are filed. Usually the cases are sent for trial. But the breaches in the national security, how are often misinterpreted. You see, to this I would just say one line: unless and until there is no smoke without fire. Let me tell you, if you are holding a position, and if that document goes out, then you are responsible. You will have to rebut this presumption. Like in Iftikhar Gilani case, he had a book, an article from a book which was already published. Now, this is a breach of national security as per the case of the prosecution. IB said that's a breach. But it was so much misinterpreted that finally the report from MI came and said, no, it is not something, it is already in public domain. So this misinterpretation is created by the agencies. Yes, it is not that there are no accused involved. There are people who are seriously involved and they are rightly convicted also. But yes, there is always some percentage of innocents also going to trial and getting convicted or getting acquitted, but they have to suffer the trial. So this I could answer this to your question.
Yeah. Next question is by Anish. So, partly it's already discussed in the presentation. So first is about RTI vis-a-vis OSA, and second is about, in line with Samath, is also asking about protecting the secret of the country. Sorry. So I'd request you that even at the cost of repetition, if you can just highlight a little bit on RTI and vis-a-vis OSA.
You see, RTI has been, there are 3 sections. I wish I could put a slide on this so that my friends who are listening could understand what RTI actually means. The RTI Act is for getting information about any subject. You want to know about any deal, you want to know about any tender, you want to know about any procurement, you want to know about any kind of, there's a provision, you file an RTI and you will get an answer. That's one thing what RTI says. But RTI also has its reservations. If you read section 123, now I'll read the 123 for you in the Evidence Act. It says, no one shall be permitted to give any evidence delivered from unpublished official records. So the word used in section 123 is unpublished official record. Now here, the case is closed because the rest is not important, relating to any affairs of the state except with the permission of the officer or the head of the department. So if somebody who's heading the department gives a document, he's authorized to share it, but only unpublished. So when something is published, so 123 will not be applicable. This is what was held by the Honorable Supreme Court in the Rafale case. And what is it? Yes. And section 5 of the OS Act, which I read in the beginning, is also when you are in possession, you are in control, you are the person authorized to have that in your possession. Let's say a Director General of a particular directorate is having a document on the procurement. We call it, let's say, they are called NSQRs when Navy sends the requirement of helicopters or anything. They are called NSQRs. Now, I am under the possession exclusively. If somebody else has those NSQRs, so I have given those documents to someone out. But yes, somebody would file an RTI. I will not be giving you any information about that NSQR because it is a secret document. So when RTI, you cannot have everything under the sun. There are restrictions. So what is usually sent to you is, you will read everywhere that your query pertaining to these documents are hereby denied because of section 8.2 or 8.1 of the RTI Act. You will clearly read, because that is where the privilege is sought by the agencies. They do not want to share what is all. Now, you see, please understand, the classification is done because of particular reason in those documents. If those documents are given in RTI, where is the question of having any classification? So that means every document is available. Where will the OS Act go? Where will the national security go? If somebody is creating a document in the armed force, let's say an army, and says, all right, here is we need 100 missiles to be installed on the China sector. And if that goes to China, China will say, okay, install 200 because India is getting 100. So that is not a document that is a secret document. You cannot give it to public domain. So the RTI will become redundant here. RTI cannot come in a particular format to help everything, to give you everything under the sun. It has its reservations, even to the extent that if the investigation is going on in any case, if I move an RTI to know that please tell me where the investigation is going, the investigation officer of a simple case will refuse, quoting section 8, that I will not, unless and until it is closed or it is charge sheet is filed, we will not tell you details of the investigation. So it's like that.
Okay, so we have few more questions. So we are traveling here too much. So there's a question from Pratyush. So basically, he's trying to explore that can we have an additional mechanism for dealing with the speedy trial of these cases? I don't think we have that many cases, but still, your take on it would be, we'd love to have your take on that.
You see, speedy trial should be like you go to all these countries, Western countries, or I have been reading about them. Let's say they arrest somebody in August 2020. They will tell you, please come in February 21. So your dates are 15th February to 25th February. So the trial finishes in those 10 days. Now, in our country, you see, please understand, our system is not bad at all. It is very, very efficient system. I have I deal it day in and day out. The judges are, yes, overworked. There are a lot of matters they have to deal with. And there is only one person who's the judge who's sitting on that chair, who's dealing with the prosecution evidence, who's dealing with every case. Yes, there can be possibility of, having a day-to-day trial if the matter is important, where it happens. If you remember, the rape case of UP was transferred to Delhi, and Shri Dharmesh Sharma ji, who was a DJ in Tisazari court, he decided that in a very short number of time. So it is not that the cases cannot be decided. It is because the witnesses sometimes are not available. In this case, the witnesses are, in OS matters, all witnesses are government servants. So they are not available. The files are not available. So it is, but yes, I agree with you completely. The mechanism has to be there. Like in 138 cases, there is a direct judgment of Justice Dalveer Bhandari that you finish that in 6 months. But our magistrates are not able to do it because of the workload. They have 70 matters in a day. How can they finish one matter in 6 months? So the question is, we have to see the practical aspect also. But yes, keeping a person inside jail, curtailing his liberty, violating his fundamental right of freedom and life, one should be sure that all these cases should be taken up regularly on a day-to-day basis and to be completed fast.
Okay, so next question we have, that is slightly, I don't know, I can't understand exactly the implication of the question. So Rupanvita is asking that whether Official Secrets Act applies in the present era. So answer is, of course, yes. And then then applying in the Panama scandal. Yeah, so if you can just share a little bit on Panama scandal, so that will be interesting for us.
Let me be very honest, Mr. Faisal. Let's not deal with the cases which are there.
I understand.
I will not be the right man to comment on this because these cases are highlighted. But yes, I will inform Rupanvita that one thing which is very important here. That look, Official Secret Act. If you read the first two sections of the OS Act, I must read that for you. I hope I have an act here. It says the act may be called the OS Act. It extends to whole of India, applies also to servants of government and to citizens of India outside India. Okay, that's the beginning of your act. So if I commit an act and I go to China or I go to America and I involve myself into any kind of espionage or spying activities, I will be held responsible. I must tell you, the foreigners who do not have immunity here in this country are charged with OS Act and they are suffering trials in the country. So it is
from Pranita about that classification of documents. So you have already spoken on this, but still you can add on this that a government can still pass a document under the exception of RTI Act by making it some kind of fitting under some heading of RTI Act under the exception. So Pranita is basically asking. So this is already addressed in the presentation, but if you want to,
I'll just answer in one line. Pranita would appreciate it that the RTI, and you are concentrating more on the RTI because of the provision that you should get information. But where the national security is concerned, the information will be very, very privileged. You will not get the entire information. Then you talk about the 43rd Law Commission, which says because the circular is marked secret or confidential should not attract provisions of the Act. Please understand, it is not a circular. Circular is a departmental memo or a notification by a government. These are documents which are affecting the sovereignty integrity of the country, the procurements, the installations, the formation of your divisions, the army regiments here and there, the army divisions installed in the country. So they cannot be given to everyone. Each thing. Now let's talk about the Rafale case. In the Rafale case, they said, what is the pricing? They said, we can't tell you because this might interest the enemy. They might give us the details, give us the specifications. Why aren't you giving us all this? Because initially it was 500 crores, how it is now 1500 crores. So there were a lot of things which initially we were buying 126 aircrafts. Now we are buying 26 aircrafts. So there were lots and lots of discussion on this. But please understand, the more we rub the issue of national security and the more we put the issues which are very, very sacrosanct to the country's security and integrity, the governments, the department, they become more closed. They don't give you that information. And that is also not good for the public interest. Now, what are we going to now see? The small answer was we are putting a lot of missiles and the different set of equipment in that. So the question here is, what is that RTI going to help people just because there is a right to life and freedom or right to know or right to live in a democratic country? Certain classifications are required to be kept secret, and that's how it is.
Then we have question from Hari Shankar. So it's a purely procedural question about presentation of the evidence in a sealed envelope. So in such case, defense has practical rebuttal. Yeah, that's a pure procedural question. Yeah.
Well, let me tell you what is a sealed envelope. The documents, when I told you, Hari Shankar, about the inspection of a document allowed by the Supreme Court, what happens is you are charged for possession of certified classified documents. When you go to the court, you say, give me the documents. You're not giving that document. Now, the prosecution has taken a privilege to seal those documents and keep it in the lock and key, that we will not give these documents to the defense. Defense will only get the document when the witness will come, and not a copy. They can only see the document. So lots and lots of petitions are filed. In one of our petitions, we went to Supreme Court, and the Honorable Supreme Court gave us the permission to inspect. So the seal covers are opened, and then you inspect the document, and then you used it for your particular defense or arguments. Now you are saying isn't it a regular practice of the prosecution to substantiate the argument? Now they cannot argue more what is in the content of the document, whether it is sealed or whether it is not sealed. They will only say this document was recovered. The contents will be only read when the document is exhibited and it is either cross-examined or taken up in appeal. Otherwise, only the classification is read. So they get the benefit of keeping the document with themselves and only open it when the witness comes. But then you get an opportunity to inspect it and know what are the contents of the document.
Yeah. Okay. So now we have a new question. That is, OSA vis-a-vis whistleblower protection bill 2015. I think this bill has been converted into the act, but yet to come into enforcement. So how you address that, because this is one of the legislation apart from RTI where OSA is coming in complete contradiction, or rather there's a conflicting provision available. So
the Whistleblower Act was actually, it is important as of now for two reasons. Number one, there are so many scams happening all around. There are so many things which are coming in the limelight. There are so many. Now, let's say I'm working in a particular department. We are 5 people, and 4 of them are involved in a particular act, which is an illegal act, and I do not want to be a party to that. But because of my being in the line, I will automatically get involved in that act. So I come and say, oh, this has happened and please take care of it. I become the whistleblower. That this is happening in this department. Basically, this is the line under that. Now, you are saying that light of 8.2 having an overriding effect in lieu of public interest, what are my views on whistleblower protection bill revoking this immunity from whistleblowers? Now, please understand, this immunity, which immunity are you talking about?
Arshia, can you please clarify in the chat box?
Yeah, doing this immunity, I don't know what immunity is saying.
Arshia, can you please clarify in the chat box? Arshia,
I like to answer this. I would know which immunity is granted. There is no immunity in 8.2.
Okay, in the meantime, Arshia is, maybe she's trying to type. So we'll take up other issues at this moment. So we'll keep that on hold. Then next question from Arvind. Sir, IPC is not applied on this act. So, there's some clarity required for this question.
You see, IPC is a penal code in itself.
Yeah.
IPC is itself an offense. IPC is Indian Penal Code, which deals with offenses which are about mischief, about cheating, about forgery, about murder, about rapes, about waging war against the country, about various other sections, but about robberies, about dacoities. But this is a special act. That's when I was speaking, I said special law will prevail over the general law. What that means is special law is the OS Act, general law is the other acts or the CRPC or the IPC, or when they say, no, look, this we can use CRPC to circumvent it, we can circumvent the trial. So the courts have come to the view that this is a special act and it shall completely prevail over the general law. IPC is a separate thing altogether. IPC is a penal code for offenses. OS Act itself is an act where the offences are described. So it's a special law for a particular kind of acts, which are very, very serious in nature. So IPC will not be applied. Yes, the procedure in CRPC for continuing with the investigation is applied.
Yes. Then we have a question from Anka. There's a concern that, don't you think tampered evidence will be submitted in the court? And especially, so this is a very important question because of the extended definition of the term document. It includes electronic record today. And we know that how electronic records are manipulated and all. So that is even producing more breeding ground for the application of OSA. So that's a new question. Yeah.
When I am fortunately I'm representing her in the court, so she's watching the session. So
okay.
She's a very intelligent client, and she's suffered a lot, but then she's very strong as well. And what she wants to know is how she wants me to mention this so that people get educated on this. That you see, there was some tampered evidence which was submitted in the court, and it was seized by the court and electronic evidence and kept in seal and envelope in the court only. Now, what I mean is there was certain evidences which was produced in the court in the charge sheet, and then when we got that in the court by virtue of the machines which were put in the court and the documents taken out of that machine, so those documents were speaking to the contrary. So all of these evidences were then kept in the sealed cover in the court itself. So there are various, this is a part of a trial. This is not something to be spoken in favor of or against of OS Act. This is a part of the procedure of trial which happened in the court.
Yes. Virender has a concern for the lawyers, for the advocates, that how advocates should be protected. Because,
that's an important, boss. That's a very good question, Virender. I was one of the lawyers who had inspected those files. So I was very sure that all those notes which I made were completely safe and in the safe lock and key. And there was no occasion that you should be negligent or you should be careless. You should be letting anybody know that. And because that itself attracts Section 5, was you are noting down a secret document in full format, and then you are disclosing that out is a complete violation of Section 5.
Yeah, so we got a clarification from Arshia. Arshia is referring to Section 4, actually. Section 4 of Whistleblower Protection Act, which has the overriding effect on...
Right now. I don't have that act right now.
Okay, so Arshia, we are sorry.
I can give her a detailed answer on that. I don't have that act with me right now.
Okay. Arshia, if you can produce that provision, or if you can further, clarify that, so that you will be in position to explain. Anyways, we take up the last question. I think the last question of the day. Yeah, Sudev has written, trial of the defense witness allowed to refresh their memory with the document that are in proceedings. Okay, so whether it is, it's applicable or not, or etc.
I'll take that question, Sudev. He's a very, very intelligent boy.
That's an interesting question. Yes.
You see, the question would be witnesses only, not defense witnesses. I will take both the witnesses because I think he wants to know about the defense witnesses. You see, the prosecution witnesses have already given their statements to the investigating officer. And they have already either given the documents or they have shown the documents during investigation. So when they come to the court, a lot of time have lapsed. So they are shown their statement, which they were given earlier, and that is recorded in the examination in chief, which you would have read in the Evidence Act. But when a defense witness comes, he hasn't given anything to the prosecution. So there's nothing which is on the record. He will come and produce his testimony for the first time in the court. So yes, but whatever he will come will be recorded in his testimony, in his chief, but it will not be that he will be given some documents to refresh because he's coming for the first time. But yes, the prosecution witnesses, as a matter of procedure, are allowed to read their statements, or because it's a matter of procedure and they are not, even in they are told to, because if the matter goes back, and they are given the opportunity to go through their statements and refresh their memories.
Okay, I think we can stop here. It was a very long Q&A session, and it was a wonderful presentation followed by, that all the answers with all these technical questions. So I was not expecting all this tough question from students.
I must tell you, Mr. Fazal, I have one compliment for the new generation. They have actually completely surprised me. And the people who come to our offices for internships from various universities. These youngsters are very, very smart. They are very focused. They know, they understand very fast. I mean, like the research the style is different. Their application to each section, their application to, what I say is that the treatment to the entire proposition, whatever we give them, it's very different. It's very nice to see such youngsters coming over. And I'm sure they will have very, very good future, because this is the profession these days. And if they work hard, they're going to be excelling.
Yeah, in the meantime, Arshia has written clarification that, now in the new act, they have removed that particular immunity. So I think we should not worry too much about Whistleblower Act.
Yeah. If you see this, anything contained in the US, any public servant may make a disclosure in public interest. No, but the disclosure cannot be public. Correct. Now that disclosure, if he will become a whistleblower, he gets immunity only if he files a complaint. It's not that he can take out a file which is a secret file and publish it on the internet or in the magazine. That immunity he gets only to the extent that I am giving this to you, but he cannot give it in the RTI. Let's say, Arshita, you file an RTI. They will not give it to you. That you say, oh, look, you are a whistleblower, you give it to me. It says, notwithstanding anything in USA, any public servant may make a disclosure in public interest. Now, that public interest has to be in the form of a complaint. That is why he's termed as a whistleblower. He cannot be termed as something else. So he says, instead of becoming an accused to a conspiracy which attracts OSA, he becomes a whistleblower. Like you have 306, if I may tell you, if I take you back to 306 of the CRPC, which is pardon to a accomplice, where he comes and says, I want to be a public police witness, you give me pardon. So that is from where they have taken this whistleblower thing, that CRPC has 306, where the pardon is granted if you support the prosecution version, and then you also have this particular act where the whistleblower gets immunity if he files a complaint or if he gives it and gives the disclosure in public interest. But I must come to that once again in 8.2. Please read it once again, which says, if public interest in disclosure outweighs the harm to the protected interest. This is the most important line.
Yeah. I think now we must close the session because we have taken a lot of your time. So it's time for formally, closing. But it was a wonderful, wonderful session. A beautiful explanation, and lot of comments. People are writing appreciation. You can read for yourself. So it's like a very, very thought-provoking session. So I would like to invite Shreya for formally closing for a vote of thanks. So Shreya, now you can just carry on.
Yes, sir. I'm audible.
Yes.
Yeah, go on, Shreya.
Yeah. Yes, sir. So, as the co-convener of Society for Advancement of Criminal Justice, I take this opportunity to thank Maninder, sir, for joining us in these tough times and sharing with us your valuable thoughts. So, we are truly privileged to have interacted with you and learn the nuances and intricacies of the topic, Official Secrets Act. As Fazil sir said, the presentation that you gave was wonderful and sufficiently detailed, and the mode that you adopted of analyzing each and every aspect of the act while talking about the nature and scope of the act, the amendments, and other pursuant case laws and instances has helped us greatly in make a greater understanding of the Official Secrets Act. Also, I would like to thank Fazil sir, our professor and faculty advisor, for succinctly moderating the session and briefing us about the topic. At this point, I would also like to express my gratitude to our Honorable Vice Chancellor sir, the faculty members at NUJS, and the faculty advisors of SACJ, Fazil sir and Sujakanta Baladhikari sir, for their constant guidance. Also, I would like to thank Sudev, who helped us a lot in organizing this session with Maninder sir. At last, I am thankful towards all the committee members and all the people who joined us today and came up with such wonderful and intriguing questions, which helped us make the session even more engaging and interactive. So thank you everyone for joining us today and making this session successful. I hope that all of us are taking with ourselves something from what has truly been an enlightening session. Thank you so much, sir, for this session. Thank you, everyone.
Thank you so much, sir, on behalf of.
You have a safe time, guys.
Yes.
Thank you. Bye.
Thank you, sir.
Thank you, sir.